Of the 74 reported opinions, 65 identify counsel by name, 37 involve Jewish lawyers opposing non-Jewish lawyers, 13 is Jew versus Jew, and 13 involve non-Jewish lawyers on both sides, with one representing a substantial mix of ethnicity. So without accounting for the 10 opinions that don't name counsel, 50% of the cases involve Jews against non-Jews, and another 17% of Jews versus Jews. I don't know the ethnicity of the corporate clients, but one can suspect. A total of 67% of the derivative suit cases then were brought by Jewish lawyers. And of these 64, 58% were Jews versus non-Jews, and a total of 78% when you add Jew versus Jew. On either calculation, these numbers seem to provide fairly good evidence for my conclusion that plaintiff's derivative litigation was Jewish business. And as we saw, most Jews didn't represent a corporate clientele, so we can make a fairly good guess as to the ethnicity of the executives that were being sued in the corporations. Combined with all of this, and the particular type of anti-Semitism that pervaded the upper and professional WASP classes, the rhetoric of the Wood Report tells us exactly why derivative suits were considered to be such a significant problem, despite the reality of their relative innocence and the lack of serious public concern with the issue. The reason, of course, is the irritation and vexation felt by WASP lawyers and their clients at having to defend themselves against the annoyingly and decidedly low-life upstart Jews who were demanding an equality which the WASP aristocracy was not willing to grant. Indeed, John Higham illustrates this nicely, and I quote, "And discrimination reflected as it had for 50 years a conjunction of two factors, the great but insecure inequalities of a middle-class society in which men striving for distinction feared inundation, and the urgent pressure which Jews, as an exceptionally ambitious immigrant people, put upon some of the more crowded rungs of the social ladder." Higham goes on describing the discrimination in the period immediately before the Wood Report as a period of status panic, and sees the very success of the Jews as the cause of social anti-Semitism. And he, again, I quote, "Whereas other European groups generally gained respect as assimilation improved their stature, the Jews reaped more and more dislike as they bettered themselves. It is the temerity of the Jews to challenge their betters that led to," and I quote, "the universal revilement of derivative litigation. The derivative suits generally were meretricious, and that recovery was so de minimis to make them a waste of time fall on the facts that I've already referred to. There's one other possible argument, I think, that transcends anti-Semitism as an explanation for why derivative suits were viewed as so threatening, an argument that's highlighted by Carlin's conclusions that ethical behavior was a function of bar status. I was interested to listen to Sam. I have a list of Carlin's ethical violations, 90% of which no human being would consider an ethical violation, and some would consider good conduct. And that is to suggest that the animosity was less driven by hatred of Jews than by class difference. But this answer is almost impossible to sustain. First, if that were the case, that the plaintiffs' bar were made up largely of Italian and Irish lawyers, we might have a plausible story, but it wasn't, so we don't. There was, of course, elite discrimination among those groups, against those groups too, but not only did it never come close to reaching the extent of anti-Semitism, but these were ethnic groups that themselves were participants in the widespread anti-Semitism. Moreover, they had their own carefully defined economic roles in the trades, the police, politics, civil service, and shopkeeping, which were never the province of the WASP elite, and therefore there was no competition or fear. Besides, if class were the issue, it ought to have been the case that the lower-class Protestant lawyers fared as badly as the lower-class Jewish lawyers from their matriculation into college until their retirement from law firms, but the evidence that we've examined suggests precisely the opposite. Lower-class Protestants, and particularly academically unsuccessful lower-class Protestants, had almost the same chance to attain elite status as did wealthy and academically successful Jews. Finally, it's worth repeating, as Digby Baltzell notes, that the WASP elite largely defined itself in opposition to Eastern European Jewry to a far greater extent than the negligible notice it took of other ethnic minorities. The class argument falls apart on the facts. Now, just to conclude, anti-Semitism in America is no longer the problem it once was. That's certainly not nearly to the same extent. But the very same attitude towards plaintiffs' lawyers that brought the early legislation about, this attitude of suspicion and mistrust in contrast to implicit faith in corporate America, a faith that seemed unshakable just 7 years or 8 years past the 1929 crash, is the same attitude of distrust towards plaintiffs' lawyers that led Congress in 1995, as part of the Contract with America, to pass alleged securities litigation reform. Legislation that severely restricted the ability of plaintiffs' lawyers to bring securities class actions, which since the 1960s have dwarfed derivative suits as a means of enforcing integrity in corporate management. The 1995 Act, much like the Wood Report, was based on anecdotal testimony and lobbying pressure, not statistical evidence, not even the flawed statistical evidence that the Wood Report purported to have. And it continued the dismantling of the securities laws that began in 1975 in Chief Justice William Rehnquist's only securities law opinion, in which, using a term that appears in none of the briefs, he referred to vexatious litigation. I'm not suggesting that explicit anti-Semitism or even implicit anti-Semitism played a role in the latter developments, but I am suggesting that it provides yet another example of the fact that our social, political, legal attitudes are very much products of a history that becomes repressed over time. Stereotypes persist long after actual prejudice may have abated. It's striking to read the hearings on the 1995 Act and see Senator Phil Gramm, for example, ask Mel Weiss, how do you pronounce that name? In any event, it's a good idea to examine these sources from time to time to remember where our attitudes came from. Perhaps if Congress had been aware of the source of these attitudes in 1995, the Act never would have passed. At least it might have led Congress to demand actual empirical evidence of the harm of stockholder suits before passing it. Perhaps had the Supreme Court been conscious of this attitude, its 30-year cutback of securities laws wouldn't have happened, or at least would have been based on sound reasoning, or the briefs. And perhaps the continued enforcement pressure on corporate America of a vibrant plaintiff's bar might have helped limit the kind of damage that we see today. Perhaps not, but thanks to the image of the corporation plaintiff's lawyer that drove the enactment of Section 61B and that has continued to pervade the corporate bar, we'll never know. Thank you.